Okay, cool. Perfect. So this is another small claims tutorial. So as you can see at the top here, we went over these, right? Consideration for filing a small claim suit. These are the questions that are typically asked prior to filing a small claim suit. Once you've tried to reach all reasonable means of the problem, and if there's a valid claim, you have evidence, and it's less than $8,000, you can do small claims in the state of Florida. Cool. When it's filed, a pretrial summons is issued, right? At the pretrial, the plaintiff, person filing the claim, defendant, person the claim is against, meet with the mediator, try and reach a settlement. If the party is unable to reach a settlement, the case will be set for trial. The county judge will hear the case and render a written final judgment. The party awarded the final judgment may have the judgment recorded into the official records. You want this. We always want to get in official records in case there's a need for an appeal. You want the official record of everything, basically. The additional fee is worth it, trust me. The judgment will then act as a lien against the real property, real estate, the losing party may own in the county where the judgment is recorded. So that's always cool. We put a lien on the business. That way they have to pay you first, any money comes in. The prevailing party may also obtain a writ of execution that may be filed with the sheriff along with instructions for levy. That just means if they lived in the state or county, the sheriff would then have a reason to go get them. The sheriff will have a fee associated with the service. The prevailing party will have to provide the information to the sheriff, the personal property of which they wish to levy. Where to file your claim, right? Where the contract was entered into. If the suit is on an unsecured promissory note, the note is assigned and where the maker resides. If the suit is recovered property, foreclosure or lien. Where more? Oh yeah, this is basically just telling you where to file it, but all this stuff doesn't matter. Any location agreed to in the contract. In action for money due if there is no agreements as to where suit may be filed, where payment is made. Collection, right? Now, this is the part that most people miss, right? It is a responsibility of the prevailing party to collect on the final judgment. The collection process can be time consuming and expensive. This just means if you don't file properly, if you don't do the official records and you don't do what you're supposed to do, you can still win a case and be, let's say, awarded $100,000. But if you don't know how to collect, you're not gonna get the money. So there is a way to ensure you get paid, right? Steps to collect on final judgment: record a certified copy of the final judgment in the official records of the county where the debtor owns real property, right? And again, we're not really gonna get to this point. They tend to settle. So it's not, we shouldn't have to get to this point. Most times when you see a court case on PACER, it's because the plaintiff wanted to go to trial. But you really don't see too many cases like that because most people who file it, they just settle out because they just want the deletion. And it saves everybody time and money and headaches if they just take the deletion versus trying to get monetary damages out of it in the long run, right? But in case you do get that far, this places a lien on the debtor's real property in that county. There's a fee for the clerk to perform this service. There's a fee for everything. Take a writ of execution to the sheriff's office in that same county for the sheriff to docket the judgment. Now, if they're out of the state, this would be the U.S. Marshals and it'd be a federal court. It would not be in state court, right? So we're doing small claims, which is typically state. If you wanted to do federal, it'd be U.S. Marshal and they can go wherever to get whoever, right? A writ of execution is a document written by the clerk of the court, which directs the sheriff to levy on personal property. The prevailing party must complete the instructions for levy describing the property owned by the debtor, which they wish the sheriff to levy. Sheriff can seize the property and sell it to satisfy the judgment. Love it. There's also a writ of garnishment, which can be issued for garnishing wages or bank accounts. This is legal. Can't do this. However, this is more involved in the legal process and usually requires services of an attorney. It does not require anything because it's illegal. So ignore that. But those are the steps. Like, these websites are very helpful. I mean, you can really get all the information you need online. You don't need to go to the courthouse to ask the court of clerk for any information. It's all found online. And then you really go from there. As soon as you've already tried, like if you're doing round 1, 2, and 3, you've already tried talking to them, they still didn't give you a desired result, file a lawsuit. And then you'll get somebody to actually pay attention to it. Because once that lawsuit is filed, the lawyer then reads what the issue is and advises the client, which is Experian, TransUnion, Equifax, that, hey, you guys have violated this dude's rights. Stop, e-Oscaring this person and just give him what he's asking for. And that's basically it. That's small claims in a nutshell. So boom.